Assalamualaikum and salam sejahtera. My name is Deni Ifan bin Haris Faizila. My matric number is S55994. So today I want to present the question number 9. So the question 9 is, Rizal bought 2 slice cake from best cake shop. He shared it with his brother John. While eating the cake, his mouth was injured due to a piece of broken glass found in the cake. His brother also suffered a similar injury after eating the other slice. Advise Rizal and John as to their rights against best cake shop. The first legal issue is whether Rizal can claim for damages against best cake shop. In section 68 clause 1 provides that where any damage is caused wholly or partly by a defect in a product, the following person shall be liable for the damage. The rule is, to succeed in a product liability claim, the plaintiff has only to prove damage, defect in the product, and causal link between the two. The first requirement is damage or injury. The rule is, section 66 define damage to mean death or personal injury or any loss of or damage to any property, including land. In the case of Donahue and Stevenson decided 1932, the claimant sued a manufacturer of bottled drinks for injuries she had sustained after consuming ginger beer in a opaque bottle, which had the decomposed remains of a snail inside it. The injury here is a stomachache. So the application is, the injury he sustained injured his mouth due to eating slices of cake he bought at best cake shop. Therefore, the first requirement is fulfilled, as there is damage or injury sustained by Rizal in accordance with section 66 in defining the damage. So the second requirement is defect in the product. The rule is, the product must be proved to be defective before liability can be imposed on the defendant. Defect which occurs during the process of production, due to a miscarriage of the process of construction or assembly of the product or its container, or an unintended ingredient or defective raw materials, may be responsible for the damage based on the case Donahue and Stevenson. So the application is, the said defect which is an alien object, i.e. the broken glass happened to have entered in the cake during the process of making it, and this defect is responsible for the injury sustained by Rizal. So the third requirement is causation. The rule is, the plaintiff must establish a causal link between his injury and the defect in the product. In the case of XYZ and others and Sharing Healthcare Limited decided 2002, the products, different brands of the oral contraceptives such as Femidone, Marvelon, Minolate, and Mercilon. Allegation was the side effects in the form of various types of cardiovascular injuries such as deep vein thrombosis, pulmonary embolism, strokes, and others. The court held that there was no proof that the drug carrying excess risk of venous thromboembolism, and the product therefore was not defective and was not the cause for the alleged side effect. So the application is, there is a causal link between Rizal's injury and the defect in the product. Rizal get his injury at the mouth due to eating the cake he bought from the best cake shop, which happened to have a piece of broken glass inside of the cake. Therefore, the third requirement is fulfilled. When all three requirements fulfilled, Rizal can claim damage. Exemplary damages. The rule is, in Rooks and Bernard and Castle and Company Limited and Broom, there is jurisdiction for its grant in products liability at least where there has been a deliberate and outrageous disregard of the claimant's right, and possibly even where all that is shown is a very high degree of negligence. So the application is exemplary damages can be claimed based on upon the claimant's right, as it is a very high degree of negligence made by base cat shop, as it is very unnatural cost of things for a piece of broken glass to be found in special damages. There was no information regarding where Rizal has been treated. If he was treated in public hospital, Rizal can claim full payment of the medical expenses by applying the rule found in the case of Chai Yi Chong and Liu Tai, which the rule stated if the plaintiff seeks the medical treatment from public hospital, the court will award full payment of the bills from the hospital. However, if she was treated in a private hospital, the court will award 1/3 payment of the bills from the hospital. Therefore, Rizal can claim medical expenses under special damages. The second legal issue is whether John can claim damages against Best Cat Shop. Position of John in Consumer Protection Act. The rule in the case of Donoghue and Stevenson, the claimant sued a manufacturer of bottled drinks for injuries she had sustained after consuming ginger beer in an opaque bottle which had the decomposed remains of a snail inside it. The ginger beer was not bought by her but by a friend. So the application is John can claim for his injuries, although he is the third party in the contract. John cannot claim his damages under SOGA. It is because privity applies. Only parties to the contract can bring action. The third party requirement is fulfilled. All the requirements are fulfilled as John's case must be regarded as the same in Rizal's case. Therefore, John can claim damages same as Rizal claim for which is special damages and exemplary damages. So the conclusion is Rizal and John can both claim for special and exemplary damages against the Best Cat Shop.